All right, welcome back to Dirty Hands of the Republic. We're going to talk about AR pistols and the pistol brace rule that has just been brought upon us.
Dropped.
Yeah, just dropped on us by the Bureau of Alcohol, Tobacco, and Firearms. We pulled out the Department of Justice publication that came out last week. And let's see, I think it came out on January 19th, if I'm not mistaken.
Yes, it did.
And essentially what they're doing is trying to make every AR pistol and every configuration like that, you know, whether it's a 300 blackout or 7.62 by 39.
Yeah, whatever the caliber is.
Yeah, I think their end goal is to make all of them short-barreled rifles.
Obviously.
And where do I get that? Okay, so there's a 293-page publication. You can work through all 293 pages, and I've gone through that, and where I think I see the core of their argument is on page 110 and then page 134. So if you happen to pull it up and you start reading it, I focused on what the ATF is talking about on page 110, where it says, and I'm going to try to be brief about this, the department concluded the proposed worksheet 4999 is unworkable, first because section 2 of the worksheet improperly considered the design of the brace separately from the configuration of the firearm. Right. Okay. And worksheet 4999 is the point system that they've come up with to try to ascribe points to a weapon as to whether or not it's importable or whether or not it's distributable as a non-NFA weapon or it is an NFA weapon. Anyway, further, section 3 of the worksheet focused more on certain factors concerning the effectiveness of the brace. Now, what is a brace? Steve brought one with him. And show that to the camera. And we have pictures of it where we took it to the range and used it as its intended purpose. And it works really well for what its intended purpose is without it being an NFA item. And, you know, we'll let that video roll while we're talking. The department agrees, and when they say department, they mean ATF, agrees that the proper inquiry into determining whether the firearm is designed, made, and intended to be fired from the shoulder should look at objective design features common to rifles. All right, stop there. Now, what does that mean? So they're looking at the overall length of the weapon, the barrel length of the weapon, the extension of the buffer spring into what would normally be a collapsible buttstock to the rifle. Right? But for a pistol, doesn't have that. All right. That's important. That's a distinction without a real difference when you get to page 134 of this publication. All right. So you go down to page 134, and this is what it says. I'm sorry. It's not page 134. It's page 132. So you got to go to page 132, and you start to see what it is they're going to do in the future. So, nevertheless, and I'm going down to the last paragraph on page 132. Nevertheless, because both the GCA, which I believe is the Gun Control Act, and NFA, the National Firearms Act, define a rifle as a weapon designed, made, and intended to be fired from the shoulder, surface area remains a relevant consideration because they're talking about the buttstock, right? Mm-hmm. The surface area of the buttstock, I'm going to insert those words there because that's what they mean to say, remains a relevant consideration because having a rear surface area is necessary to shoulder a weapon. Therefore, the department has concluded that any surface area provided by an accessory, component, or other rearward attachment, ergo a stabilizing brace, would be an example of what they're talking about, must be considered prior to the other listed objective design features of this rule. In a rifle configuration, a rear surface area is often provided by a stock, shoulder stock, or buttstock as demonstrated below. Okay. But here's the thing. The surface area of the buffer tube is enough to fire the weapon from the shoulder if you want to get completely superfluously technical about it. In other words, and if Steve wants to demonstrate or if you want to demonstrate, you can just put the buffer tube up to your shoulder and fire it as a rifle theoretically if you wanted to. But that's not its intended purpose. So for me, it becomes arbitrary and capricious for the Bureau of Alcohol, and it also becomes excessively vague. Everything that's on page 132 and around page 132 of this report is excessively vague when they start talking about surface area and what they're going to consider to be sufficient surface area to validate an argument that you're using that stabilizing brace as a buttstock. Mm-hmm. In order to make that an NFA item, because what they really want to do is turn every AR pistol into a class
SBR,
3 weapon.
Yeah.
A short-barreled rifle.
Yeah.
Yeah.
An NFA item.
Yeah. Mm-hmm. To create a registration of all of those for that purpose. And for any and all purposes. In other words, if you're a police officer who uses it on duty, they don't care. Right?
Yeah, and a lot do.
And one of the things that has always vexed me, I guess that's the word I want to use, is the fact that police officers aren't issued suppressors, right? Because you search buildings all the time, and officers have to get into shootings all the time. Why officers aren't issued a suppressor is beyond me, because the likelihood you're going to need it is dramatically greater than the average public, and the average member of the public. Yet, for some reason, it seems like it's easier for an average member of the public to get a suppressor than a police officer.
Really?
Yeah. Because, you have to form a trust, and then you have to buy the suppressor in the name of the trust, and you have to go through all that nonsense. They don't lighten that requirement for police officers at all.
Oh, well.
So
Probably because the 16.5-inch barrel, which is already a musket, if you're in a car or in a building, then it makes it like a long Tom goose gun with a suppressor on it.
So do you find, okay, so the rule is 16 inches or greater for a rifle. They must have a barrel length of 16 inches or greater. Mm-hmm. Okay. But when you use an AR pistol to search a building at night, like, you're looking for burglary suspects or something like that, and you're using an AR pistol in whatever configuration, do you find that it to be a better weapon to search tactically a building at night?
Oh, yeah, definitely.
Okay.
I mean, the advantage of a short-barreled rifle or a pistol with a brace on it is still the same thing, basically. Okay. And I'm not sure who decided in the government thought it would be okay. What if I want to hold it against my nose or against my groin? Okay, where I hold it shouldn't be any of their business. But anyway, yes, until you have actually trained with a 16.5-inch barrel in an AR in buildings, in the shoot house, in the Sims house, and then gone on warrant services with them, and then go with a short barrel, it's so much of more of a tactical advantage that police officers should just be able to use them anyway. I mean, it is so much more of a tactical advantage.
But we're big supporters of the Second Amendment, so we're not here just for police officers. I think any citizen should be able to.
Oh, I do too. Yeah,
utilize this technology, this weapon, right? And what you wind up with is having to decipher how the ATF is going to interpret the surface area of the back end of your AR pistol to determine whether or not it's a short-barreled rifle, right? And so with this very vague statement about surface area in determining what a buttstock is, I think the ATF is creating this vagueness.
Oh, certainly.
On purpose.
Certainly.
So that ultimately they can turn every AR pistol into a short-barreled rifle. Mm-hmm. I think that's their intent, if I'm being completely honest. And they're starting with the brace, right? The stabilizing brace. They're starting there because they know they can try to at least make a case. And the reason it's 293 pages long, this ATF publication, is so they can try to defeat the argument that they're being arbitrary or capricious. Mm-hmm. This is what they're going to walk into federal court with and say, no, we were not arbitrary or capricious about this, Your Honor. Here's 293 pages of us not being arbitrary about this. Right? But if you actually really read the document, there is such ambiguity and vagueness within the document itself that they keep making the judgment of the weapon a very subjective one.
That's a very good point you make. You're the first attorney I see that has pointed that out about the surface area on the butt.
Yeah.
Okay. I mean, everybody else just talks about the length of the overall length and the length of the barrel.
Yeah. But that's not the true and purpose of this. The true purpose of this rule, this publication, is to try to defeat in court the argument that they're being arbitrary about how they are describing a rifle, a short-barreled rifle, right? And their true intention, if you can pull the vagueness out of this publication, which I really believe hovers around page 132 and beyond, what you realize is they don't want there to be a hard and fast law about the surface area of the buttstock of the weapon, so they can make it whatever they want.
Yeah.
And by doing so, it becomes this vagueness, this ambiguous kind of standard that the ATF can apply at will whenever they feel like.
Yeah. Well, now,
against whoever they feel like.
What do you think the chances of this passing muster, since the other decisions have come down about like the bump stock and
all right, so we're talking about the Cargill versus Merrick Garland decision that came out of the Fifth Circuit. All right, so I think the Fifth Circuit, which is where we are in Texas, Louisiana, Arkansas, Oklahoma, right? That's the Fifth Circuit Court of Appeals.
Yes.
All right, and they're based in New Orleans, Louisiana, have come to the conclusion that the bump stock ban from the ATF was, well, essentially arbitrary and capricious, and was not, Congress has to make the law.
Yes,
the ATF can't make
That's
the
what
law.
they said in their decision.
Right.
But what do you think of the chances of this one passing muster, the brace one?
Well, if the court applies the proper standard, it should fail the same as the buttstock.
Okay.
And it would fail based on the fact that Congress does not allow the ATF, in my humble opinion, to create the legal standard of what is a rifle, right?
Or a machine gun.
Well, forget machine guns. This is not about machine guns. This is about what is a rifle. What is a short-barreled rifle, right? That's what this is all about. What is a pistol? Is an AR pistol a rifle? No. Is an AR pistol a short-barreled rifle if you have a stabilizing brace on it? No, because the purpose of the stabilizing brace is to be able to use it as a pistol, which we've shown in the video.
Yeah.
If you're using the device as it's intended, anything can be abused. This is my problem.
Yes.
Any accessory, anything. I've been doing this for 30 years. I have seen things, made and remade 100 times over because people want to try to outsmart the law or something like that. But ultimately, it's up to Congress, not the ATF, to create the standard. And when the ATF is making the standard and not Congress, in other words, if the description of rifle you're using is not found in Title 18 of the United States Code, but you have to go scrolling through 47 CFR, which is the Code of Federal Regulations, to try to figure out how the ATF is going to interpret the manifestation of your rifle to make it a short-barreled rifle. That's outside the bounds of the ATF. That's outside the bounds of the administrative state.
Okay, but in the meantime, what should we do? Comply?
Well, you have to until you can get into district court and a judge sees the difference between Title 18, United States Code, Section 921, where a rifle is defined, and this one, which is found under, I think it's 47 CFR, might be 48 CFR, where they try to change the definition of what is a rifle in order to make an AR pistol a short-barreled rifle under the National Firearms Act. So it's 27 CFR parts 478 and 479. Not 47, but 27 CFR, which is 27 Title 27 Code of Federal Regulations, which is where the ATF tries to redefine what a rifle versus a short-barreled rifle is. Okay. And where they're attacking AR pistols is on the back end.
Basically. Literally.
And they're trying to do it by redefining what is and what is not a buttstock.
Yeah.
And the way they define the buttstock is to make it so vague that surface area of the buttstock doesn't matter. just whatever we think it is. And that's basically the ATF's position. And you don't really understand what they're trying to accomplish until you get to page 132 and you start reading into how they're trying to determine the validity of a buttstock, that you realize what they're trying to do. All right, Steve, thanks for joining us, man. We appreciate having you. Come back anytime. Joseph. And everyone, we'll see you in the next video. Like and subscribe. Always comment below if you would actually like to join a lawsuit because you are an AR pistol owner. Our information will be in the description section. You can contact us. We'd love to talk to you and maybe work out how we can file a lawsuit against the Bureau of Alcohol, Tobacco, and Firearms.
Tyranny.
Although really we'll be going up against the Department of Justice is who we'll be going up against. And it so for example, in the Michael Cargill case, they sued Merrick Garland and the United States Department of Justice, and then the Bureau of Alcohol, Tobacco, and Firearms. That's who they sued. So that's who.
And won.
Huh?
And
they won.
And they won.
To their credit. So, all right. So anyhow, we'll see y'all in the next video. Like I said, like and subscribe. We read every comment, and we'll see you in the next video. Thanks.